Good afternoon. It's February 11, 2023, 11:22 a.m. Just got back from my little walk, and I decided that there was something else I needed to say regarding the um, recent ruling by the Privy Council regarding attorneys having the mandate to report criminal activity of their clients, especially was the stresses on money laundering. But as I've indicated in my previous video, it's not just about money laundering. The ruling and the application to the Privy Council really goes way beyond money laundering, because it goes to the heart of corruption in the courts and attorneys who manipulate the legal process to commit crimes, including money laundering. And as I've also indicated in my previous video, collecting illegally earned money from your clients, then running it through your bank and claiming it's a retainer, it's also money laundering, because you know it's illegal money. And the law of the land is that you must be aware of who your client is. So you should be well versed of where they got their money from and how is it that they have all this money to pay you, which is in recent times millions of dollars for a retainer, even in civil matters. So it applies to both civil and criminal. There's no limitation. And as the attorney I mentioned before, Bert Samuels, I didn't get to check it yet, but yeah, Bert Samuels, as he said, it's heavily leaning towards civil attorneys who have long evaded the arm of law in Jamaica and the long arm of law from the United States, because they facilitate a lot of the illegalities, illegal acts by these people, including removing people from the planet, causing them to disappear by whatever means, but all illegitimate, and therefore avoid going themselves and spending the time they deserve behind bars. So again, attorneys who collect money from their clients must justify where that money comes from. There must be a paper trail, and the paper trail must correspond or support the paper trail of their clients. Where did they get that money from? And it could be generational, because if it's money they got from a parent, a friend, a couple of people, those people now are subject to providing evidence where they got the money from. And so the effect of the ruling is that we should see more people being discouraged from committing crimes, more people losing the ability to use attorneys to circumnavigate the judicial process by various means, whether it's dilatory, causing your files to disappear, whether it's with a friendly judge, a drinking buddy, or social partner. It doesn't matter. Now all those persons in the courts are subject to this ruling, and the ruling goes beyond just simply collecting money and washing it. Goes way beyond that. Now I wanted to make a comment on this ruling and how I've seen it to affect the whole Mr. Bolt's saga and the scenario around Mr. Bolt and the other persons who have lost money or were robbed by SSL's employees or the directors. We're not sure of whoever or how many are involved, but the allegation is now pointing at a consciousness of everybody who is anybody at that firm, knowing that some illegalities were unfolding. And it would also support the fact that because the Prime Minister moved his money, didn't even take time to notify other government agencies to move their money, because I think possibly he didn't want to alert them that something was going on. He was aware of it, which would mean insider trading, which is illegal, and he would be more or less in conflict there would be a conflict of interest in what he did. Ethically and morally, the facade and the veneer being painted is that he was also aware of this, and so was his alleged friend who moved to open another agency, suspiciously again, just before the exposure of the ongoing criminal activity out of that firm. So I had indicated to Mr. Bolt a couple weeks ago in previous videos that I would not waste my energy on getting involved with the criminal matters as it relates to prosecution. The state is supposed to do that. But I'd also suggested that if I were in his position, I would take civil action, file a lawsuit against everybody, including including the prime minister who moved his money, as being complicit. He was knowledgeable of funny things going on over there. He didn't do anything to protect your interests. So technically, the government, not the government itself, but the prime minister personally, would have some liability as it comes to getting back your money. And the reason I would pursue litigation in that direction is also because it was just recently announced and published in some Caribbean or online forum or platform that the Prime Minister, money that they have identified that the Prime Minister has, his net worth is over 40 million US dollars. Now, as far as I'm concerned, if you take 12 away from 40, the Prime Minister still has 30-something million left. And if indeed he has some liability, he should be made to compensate you and the other parties from that loss. So I'm encouraging you to file a lawsuit and list the Prime Minister, have your attorney file an injunction against all his assets and the assets of every party listed in that lawsuit, and then have a freezing order done on any assets so they can sell it, liquidate it, or other. And in fact, when your attorney files that application for the freezing order, let the court make it effective from the time you deposited your money in SSL, and so it would become everything that transpired from the time you deposited your money until now would be subject to that lawsuit and the injunction. And the fact is, if there are liabilities, then the Prime Minister needs to explain to the country formally and in that lawsuit that why he again didn't take action to protect the country's money as well. So those agencies, government agencies that were exposed, they are exposed to potential loss of every dime that the country has in there. So the public defender should file a lawsuit that includes or against the Prime Minister themselves. Now, I have said we have to be proactive in what we do. We have to be more sophisticated. We can't just sit around and become the fiddle and be played by people all the time, which is what happens, and then they quietly make this thing disappear for all the persons who could have done something to protect the Jamaican people, the investors, people who view this country, and in short, damage the economy of the country and the perception of people around the globe and in the diaspora that are Jamaicans, and even nationally and locally, that we are a bunch of thieves. So again, I would definitely file a civil suit against all those parties that the press or media has suggested or exposed as being complicit. They knew about it and they took measures to protect their money and their resources while sacrificing you and the other persons. I'd also suggested that if you didn't want to effect this legal action on your own, then the other parties could go ahead and you and them do a class action suit. And so again, use that lawsuit to freeze all the assets of SSL from the civil perspective, and all the assets of the persons who work there, everybody. I mean, from the janitor all the way up to the top. Have that injunction, put a freezing order on all their assets, all their bank accounts, until people start spilling their guts and become evidence for the real persons who took most of the money, if not all the money. The other thing I'd like to suggest, that if it was me, especially with the ruling of the now Privy Council ruling about attorneys must know their clients and provide evidence of crimes, all these people who are now running for cover have probably retained attorneys, and the evidence in front of the world is that these persons were directly involved or complicit in the crime that took place at SSL, which means all that money that was stolen, defrauded, or taken, or in hiding is illicit money, illegally gained money, fraudulent conversion, and so that money becomes subject to the current ruling of the Privy Council. So one of the things I do is have my attorney, if your attorney, and your attorney that I heard or saw in the paper that represents you is an experienced attorney, whether he wants to go against other attorneys or not, I don't know. But if he's representing you, he should follow your instructions. And the instructions I would give to him is that file not only the lawsuit that I suggested earlier and apply for that injunction which I suggested, that freezing order on all the assets, both bank accounts and everything, all property owned by them. But I would also now be using the ruling of the Privy Council to file discovery and disclosure from the attorneys and from the litigants who you file a lawsuit against. And that disclosure must seek an accounting of all the money they have, where it came from, who deposited what, when, from the time you started deposited money at SSL, the banks who conducted those transfers. They must deliver to you accounting records from all the banks, all the transactions, and that goes for everybody I mentioned that would have been in that suit, including SSL. All the accounting information, all the banking information, all the financial records showing where money went, who deposited what, and most significantly, the money they paid to their attorneys. Those funds should be also put under the freezing order, because those are funds that you could use to recover what money they stole. And where did they get this money to pay the attorneys? Now, if they're accused, and this young lady, for example, she admitted stealing money, then the money she's paying over to the attorney is more than likely money she stole. So are you telling me now that it would be okay for her to use the money she stole to pay attorneys now to come and mount a defense against the very crime she admitted she committed? The ruling of the Privy Council is basically saying that that money is illegal money, illicit money, and the attorney who received it as retainer should have known that, and the attorney, their client should have told them where that money is coming from. And if it's coming from a bank or from under the bed, then they must explain how do you differentiate it from the money you stole? How over this period, how do you differentiate that money from the money that you're paying to me, the attorney? And if the attorney took it, the attorney should either turn it over and put it in an escrow account with the courts, or with your attorney, a joint escrow account at a bank, a neutral bank, and let that money sitting there, the fees that they pay to the attorneys, because the attorneys who collected it now are technically, under the ruling from the Privy Council, liable and involved in money laundering if that money is coming out of money they stole from you and the other persons. And again, obviously, if they claim they spent off all the money that they stole, where is this money coming from? And if it's coming from a friend or relative, whatever the case may be, those people now must explain where are these millions and millions of dollars that they paid as retainer coming from. So the attorneys, for them, for the defendant, those people who scammed you or stole your money, must now give up the information. They must now turn stool pigeons. They must now become rats and squeal on the criminal activity of their clients, because that is the law. You must know your client, and you can't hide illegal activity, nor can you participate in illegal activities such as laundering your clients' ill-gotten gains. And the ill-gotten gains that they're paying you to defend them against the lawsuit Mr. Bolt and the others will be filing is money being laundered if you collect it and put it in your account. So just a short insert on that. And again, you have to act quickly, because when they move the money out of jurisdiction, then it's going to be more difficult for you to collect that money. And that's money that could be used, once you put that freezing order on there, to repay you, resettle the money they stole. And that's one way I see you getting back your money. And I said, one of the persons I listed as part of the lawsuit, the PM, the Prime Minister, would be liable for paying you back your money if he knew what was going on, because he becomes a major player in helping to be complicit, to be an accessory to the crime, and therefore he becomes liable and should pay you back once that's done. But the important thing is to drag him into court. One thing that most of us must be also aware of is that the very attorneys that this rule subjects to the law are being prosecuted for not disclosing criminal activity or laundering money, is that now we are going to be relying on the same very attorneys now to be in court fighting these matters. So shouldn't we have an independent oversight agency that works directly with the courts as a liaison between the court and the JCF to monitor these attorneys and the money they collected from clients as retainers? That obviously is money that's dirty money that's being washed by them. So we can't just rely on the trust or trust these persons. I've already proved to you the corruption that exists in the courts. There is no ifs and buts, no dispute that corruption exists there. It's not only me, international agencies and organizations have indicated it. The very Privy Council a couple of years ago, as I pointed out in a previous video, also indicated out of the courts of Jamaica they've seen some of the worst rulings, and I submit that those rulings weren't because the judges were incompetent. It was because they were complicit, and they were buddy, and for some reason they made these bad rulings because it's convenient. And the game is that most people will go to the appeals court, and when they lose their case at the appeals court because of an illegal rule in the rules of the court, which says that person needs to have permission from the very court that rule against them, which is a conflict of interest, before they can appeal, it stumps those persons for a number of reasons. One, typically when it goes to, if they try to appeal it to the Privy Council, already the case is prejudiced. And secondly, a lot of people don't have the resources to now take it to the Privy Council, which is also an unconstitutional event that must be fixed. If the last appeal part of the judiciary or the court system is the Privy Council, then everybody should be guaranteed 100% access to the Privy Council. And just like you can't tell a person they need money to vote in a general election because it's a constitutional right, then you can't tell a person they need X amount of money before they can go in front of the Privy Council, because it's a constitutional right to go to the Privy Council. So the government and the courts must correct this. It's unconstitutional, but we know it was designed to stop people in their tracks from finding justice. And those games that they play with the courts rules and they play in the courts should be stopped. And as embarrassing as it is, we have our own people now in the courts who should be protecting us, using them as tools to play games to limit people's rights in the courts. So it's unconstitutional for a rule that says a person needs the permission of the very judge or the court, the lower court, or the law, how you call it now, anyway, the lower courts, before they can appeal a matter or a decision. In most jurisdictions that I'm aware of, it's automatically granted.